two very brief submissions, and I'll not repeat what has been said by my seniors who have said or uttered something before me. And Your Honor, I am drawn to what has been annexed as JC3, being an Interpol Red Notice. And at the very end of that document, which is page 3 of that document, where they talk about provisional arrest. And it says that this request is to be treated as a formal request for provisional arrest in conformity with the national laws and or the applicable bilateral and multilateral treaties. Now, Your Honor, I'm going to particularly stress on the issue of conformity with the national laws. And I join my senior Mr. Omari in saying that this application is actually very incompetent to be in this court at this time. And for that reason, Your Honor, I'm guided by the Extradition, Contiguous and Foreign Countries Act, that is Cap 76 of the laws of Kenya. And in particular, I'm drawn to Section 5 of that Act, which deals with the requisition for surrender of what they term as a fugitive criminal, or what this Interpol Red Notice call fugitive wanted, a wanted fugitive. And the beginning of this particular section, Your Honor, lays down the particular procedures that ought to be followed in the event that we are faced with a circumstance such as this. And Section 5.1, Your Honor, states that a requisition for the surrender of a fugitive criminal of any country who is in or suspected of being in Kenya shall be made to the Cabinet Secretary by a diplomatic representative or consular officer of that country, and upon receipt of such requisition, the Cabinet Secretary may, by order under his hand, signify to a magistrate that a requisition has been made and require that the magistrate to issue his warrant for the arrest and detention of the fugitive. Your Honor, if you look at this application, the prosecution has not annexed such an order from the Cabinet Secretary. And even if we were to skip the provisions of Section 5, we still find ourselves bound by Section 6 of that Act. And Section 6 deals with issues of warrant. The DCI are saying that they are enforcing a warrant. But even in the enforcement of that warrant, Your Honor, they ought to be guided by Section 6. If at all Section 5, they feel that it's not going to apply to them. And it gives two instances of the issuing of those warrants. And one is by virtue of, again, Section 5, which is an order of the Cabinet Secretary. And two, when an order of the Cabinet Secretary has not been received, but when a magistrate must endorse that warrant. So the two only the only two circumstances in which these orders may be fulfilled is when, if there is an order from the cabinet secretary, or second, if a magistrate endorses those warrants. And that is to be found under section 6.1 and 6.2. Therefore, the question before this court, Your Honor, is, has this court received an order from the cabinet secretary? And if not, has this court endorsed the warrants? And the endorsement comes because, Your Honor, you have to satisfy yourself before the arrest has been conducted that there is a reasonable and plausible belief that the documents, one, are genuine, and two, being a diplomatic issue, that the relevant state officers and players are aware and bound by such warrants. Therefore, Your Honor, on that sole issue, I humbly submit that the application is incompetent. The arrest, having been conducted without the endorsement of those warrants or an order of the cabinet secretary, is unconstitutional, and the respondents must be set at liberty forthwith. Your Honor, my second ambit of my submissions will revolve around Article 20, 24, 29, and 39 of the Constitution. And Your Honor, I begin by the premise that all legal systems, including this country, and in the application of the spirit, Your Honor, we find that the spirit of the Constitution has been defined as the transformative constitutionalism, which in essence shifts power from the state to citizens, on human rights, accountability, and inclusivity. This is done with emphasis again on key principles, which I ask this court to just to have it hang somewhere. Now we come back to it with key principles of inter alia, equality, social justice, and the rule of law. But again, we restrict ourselves to one principle, that is the rule of law, where we find that our legal system again with the Constitution being the supreme law of the land, is an ecosystem by itself, Your Honor. Where inasmuch as giving out these rights, and in particular relevant to this case is the right to liberty under Article 29 and the freedom of movement under Article 39, that even in giving these rights, it still comes back and says that everything must be done in conformity with the Constitution. And that is the purpose or per part of Article 24 of the Constitution. And I concern myself with Article 24E, which speaks to the essence that, Your Honor, limitation of any right in an open and just democratic society must be justified. And Honorable Justice Chacha Mwita in Robert Alive versus the Attorney General, that is petition 176 of 2016, goes on ahead and says that limitation should be the exception and not the rule. So much so that, Your Honor, if the exception as it is and is sought to be applied must conform to the legal principles. And what are these principles again, Your Honor? Chief and most important of them is that it is not for us to demonstrate that the respondents are not at flight risk. It is not our duty. The prosecution and the DCI are asking you to limit these rights. But what justification have they provided? I agree with my senior, Mr. Umbeta, that they have not placed any material before the court to demonstrate that these people are at flight risk. And if set at liberty today, they've made arrangements to escape the jurisdiction of this court. Therefore, Your Honor, in merging my submissions, I humbly submit that there being no basis in the form of an incompetent application, not known to them, and in the absence of materials to justify the exception, the respondents be set at liberty for. Thank you.